please the court, the next area of my submissions is the specific responses to what I will term Optis's jackpot grounds of appeal, which are grounds 2 and 3, the attendant complaints in a procedure in ground 4. Before I do so, it's been brought to my attention that obviously this is a forensic process. However, there is a transcript of what I say which goes around quite quickly, and there are two things that I'm asked to ensure there is no mistake about. The first is that my submissions this morning were that Optis's case, as you've heard from Mr. Speck, is that Apple operates a blueprint for holdout. That's what the transcript should have said. The extent that the transcript says that I was saying on behalf of Apple that it has a blueprint for holdout, that is not right.
Don't worry.
We all transpose names of parties. I do it all the time.
The second point is that by access to the standard, we're talking about the essential patents in the standard. If I had said that we're talking about access to declared essential patents, that was misspeaking, because it is accepted and common ground that there is over-declaration of these patents and that only a subset of the declared essential patents.
I remember you saying that, actually. You were reading something out. Was it something in the judgment?
I
must say I thought that's what it meant, the thing you were reading out. I understand that's not your case, don't worry, Mr.
That may, if that came from the paragraph.
It came from whatever you were reading. I don't know what you were reading. It could be something else. I don't know what it was. But I do remember that. I'm thinking, oh, that's interesting.
Well, I'm assuming that came from the judgment, and that therefore we would say is an aspect of the judgment we do not embrace. The area of my submissions I therefore come to is grounds 2 and 4, where I can, to an extent, pick up on everything that I've already now said in relation to the fundamental attack on the way that the judge approached his task. What Optis says should have been done to anchor this again is to pick 2 licenses, the Optis Google and Qualcomm Apple licenses, as his sole comparables for determining the FRAND royalties due to Optis, to unpack those into dollar values per unit, to scale them down to the Optis portfolio, and then multiply up by Apple sales volumes to get to a lump sum amount. And the guts of the workings are set out conveniently in Optis's skeleton at Annex 2 on page 131, which was briefly referred to by Mr. Speck. And you see there the 2 licenses and the unpacking of the Qualcomm license. Yes, I know. I'm not allowed to read the numbers, but you see the unpacking of the Qualcomm license in the box at the top. And if you read across from the Bizant free release row, the 3rd one down, to the dollar per unit rate payable to Optis in the right-hand column, you see a confidential figure of a certain magnitude. Below that you have Google. Ms. Guttridge didn't unpack that one, and that is why we focus on Mr. Bizant's dollar per unit figure on a free release basis in the right-hand column to compare against the Qualcomm one we've just seen. You now see a confidential figure which you've seen before from these tables Mr. Speck showed you, payable to Optis for every unit sold, which is higher. We've now gone through what these numbers translate to in terms of the bottom line and the economics relevant to the price of a handset. Optis calculates the amount that it should be awarded on this footing as the figure stated in paragraph 9 of its skeleton, several billions of dollars for what we say is both a tiny and low quality, or at most average quality, set portfolio.
Mr. Sir, can you tell me which number off the page you just showed us is the one that gets to those billions?
So of those numbers, the top one, the Google one, the 3 digits, that takes you to the top number. You go to paragraph 9.
I see.
Which begins with, yes.
Is that right? I thought they were based on the 4 numbers we see in the weighted average. Am I mistaken?
Well, I'll be correct if I'm wrong. I thought so too. That is apparently not correct. That top number comes from Google alone, not the weighted average figures.
All right, thank you. Oh yes, now I see. No, that must be right because it says or on a weighted average. Yeah. So
Yes.
you're wrong. Thank you.
So the consequence of taking, we say, either of these 2 outliers as the key comparables that should decide the result in this case is dramatic. And that is why one asks anxiously, what is the basis for the contention that this court should reject the judge's approach and substitute a result based on either one or both of these comparables? Under ground 2, if we can take it very quickly from their skeleton, the reasons why the judge is said to have gone wrong in law by not approaching the Fran valuation on Optis's preferred basis for this appeal are summarised in paragraph 89, starting at the foot of page 75, in a compressed fashion. And you'll see the references through that to the various points that I've been canvassing. Essentially, those are the ground 1 points, and I've respectfully sought to show that these are built on sand and that the judge did not mistake these basic principles. And so I turn to the procedural complaints about the methodology adopted by the judge. And there are, analytically, I think, 2 of these. First, there is the point contained in the penultimate sentence of paragraph 89 of Optis' skeleton. It's the top of page 76. And that's a specific point that what the judge should have done with the experts, where there were differences between them on issues, it was incumbent on the court to make findings as to which of the experts' views was more appropriate, essentially to choose between them. Instead, they say the judge simply classed all those differences of opinions as subjectivities that rendered the whole process useless. I've made my submissions on that. We say that's not what he did. But the procedural point remains that where you have experts before a judge, this is the way that one ought to address things. The second procedural complaint is the general complaint, which comprises ground 4 of the appeal, beginning on page 81, with the heading, "The judge wrongly adopted his own methodology." So to start with the narrower point, we disagree. The court was not restricted to an adjudication between 2 parties' experts on every individual point of difference in their reports. And that is so, we would say, generally, but particularly in these circumstances, where the context is that the judge is concerned that the experts have failed to apply sufficient independent judgment to the unpacking exercise, and secondly, as we rehearsed yesterday, that the 2 experts had failed to engage with each other sufficiently and to present agreed common workings to the court for it to use. The judge chose the approach he did essentially because he considered that that was a good fit with the evidence available in his case, something that he was able to undertake himself, and implicitly that it was not procedurally unfair. Which takes me on to that question, the procedural complaint that the judge's entire approach was procedurally unfair. This is developed in Optis' skeleton, starting on page 81, paragraph 103. And the gist of the point is not complicated. It's that the judge unfairly struck out on an entirely new course of his own. In the course of the assessment, he adopted an approach that bore no real relation to the parties' cases. Our submission is that quite to the contrary, the fundamental approach of the judge had a basis in the evidence and arguments presented. It was based explicitly on the essence of the Apple framework as the judge himself described on 2 occasions, the relevant paragraphs of 405 and 456, which we've already gone to. And of course, there was the other reference that I referred to at page 467 at the top, end of paragraph 457, where he comments that his methodology forms a part of Optis's own top-down cross-check analysis. Our submission, and there's no more points of detail for me to develop, are that it wasn't novel or maverick. The building blocks were there in the case already, and that the way that the judge implemented the approach to price the stack and allocate it was then to use as his evidential foundation to power his method the suite of the other licenses to Apple, the 18 other licenses which were in evidence, and almost all of those, all bar one, were entirely lump sum licenses. And he noted the large extent of the stack that they covered. That too, we say, was in line with Apple's approach. It was not idiosyncratic. And finally, you have the point that the judge used lump sum amounts in this approach. And that was different from the per unit or price per device approach taken by the parties, accountancy experts, following their client's instructions in the way that I outlined at the start. The way he chose to do it was explained by the judge. We will come to it in more detail under Ground 8. We say it wasn't illegitimate. It was not unheralded to use the lump sum values in Apple's licenses, which broadly assume consistent sales volumes, rather than unpack them into dollars per unit. And indeed, as I've explained in at least one respect, he was making favourable assumptions to Optis.
Just tell me, you say not illegitimate or unheralded?
I do.
Where was it heralded?
It wasn't heralded in him saying, I'm going to adopt this kind of approach. It was heralded in the material that was before him, which formed part of the debate between the parties, where the Apple methodology in particular was referred to. And the points that I took the court to this morning, showing the importance of looking at the aggregate figure and all of the detail that I explained about his analytical thinking, he took from evidence in the case.
Sorry, just to be clear, I wasn't aware, I don't recall being shown something which does with a lump sum what the judge did with a lump sum.
No, there isn't. He didn't. There is not. He did not have, or I'll be corrected because it's an important point if I'm wrong, that he did not have anything where it was scaled up to the aggregate from the individual lump sum in a particular license.
So would you accept the following summary of the position? The judge adopted his own methodology without telling anybody in advance that that was what he was going to do, and when it had never previously been canvassed. But your defence of that is you say, yes, it was his own methodology, but it was using building blocks that were already in the case.
Yes, my lord. Yes.
With the extra feature that there was no expert evidence on this method at all. I mean, the building blocks may have been there, but neither expert addressed this method.
Neither expert had addressed that method. On this point, I'll make 2 points. The first is that the experts were, as has been discussed so far, essentially doing mechanical calculations. So when one says that neither expert had done it, part of the concern is that they hadn't thought about how do I address a problem of this kind with a case of this nature. So he says to himself, I'm going to have to do that work myself. The second comment is that the judge, and it comes back to the way that my Lord Justice Arnold correctly crystallised it, that the judge had the building blocks for that in the other evidence in the case in the way that I outlined this morning. Now, I was saying that it was favourable in a way to Optis and unfavourable to Apple. That's the point that I foreshadowed earlier, which is that Miss Guttridge herself expressly acknowledges that these lump sums include consideration for other things. Yesterday, I didn't give you the reference, which you have in the bundles, to where Miss Guttridge goes into that. I'll simply state it. Supplemental Bundle 2, tab 37, and you would go to page 238 and read Roman 5 at the top. In common with the way that Miss Guttridge did things when she was unpacking on a dollar per unit basis, this judge also said, well, I'm going to adopt a different approach, but I'm going to treat that lump sum consideration as the platform for scaling up without thinking about a discount for these figures. So, my Lord, in conclusion, there's nothing further that I'm going to say about that. Those are our submissions on the complaints made about the judge's methodological framework for the Frand analysis and procedural unfairness. It's necessary also to respond to Optis's substantive points under these two grounds, 2 and 3, which power its argument that the field of comparables should, they say, have been confined to only the two, Qualcomm and Google. The line of argument has got 3 strands to it. I'll take each in turn, and on at least 2 of them, I've already made quite a lot of submissions. The first is the argument that the judge should have treated all the Apple licenses, but for the one, as unusable, owing to systematic holdout. The second is the argument that the Qualcomm license was usable on an unpacked basis, and it was an error not to have used it in that manner. The third is the argument, the equivalent argument for the Google license. It was usable on an unpacked basis, and it was an error of the judge not to have used it in the manner now advocated in this appeal. I will start with the systematic holdout point first. We've already now gone through the expression point, what the judge meant by the phrase legitimate holdout, and I'm not going back to that. Our case is that the judge had in mind the critical question whether, in the circumstances of the negotiations he had before him, the behaviour criticised can be expected to produce a depressive effect on rates, such that it undermines the significance one can attach to them. This is also the point we made in our skeleton at paragraph 94. So now I focus on this issue. Mr. Speck said on Wednesday that we had missed the entire point of why the conduct is engaged in at all. It is to soften them up so they are in a state of preparedness to accept a much lower figure and then do a portfolio deal. In other words, if Apple says to the prospective licensors on the other side of the table, even if the evidence was that this was a background matter that did not affect forthright negotiations over the portfolio in practice, and including with counterparties who have an arsenal of preliminary injunctions that they can deploy to shut down Apple's business in various parts of the world, Still, Optis says, look at that undesirable ingredient. That undesirable ingredient was conduct that is such that you can expect rates would have been brought down to sub-brand levels. And we say that the key question for the court to be kept at the forefront of one's mind is the actual practical effect of the relevant behaviour when seen in its commercial context. The judge heard evidence that in licensing negotiations, both sides do conventionally approach global portfolio licensing using a set of assumptions and using sampling. In fact, the judge looked specifically at the question whether there had been such a depressive effect, or could have been expected to have been, taking into account the commercial context. He specifically reminds himself at several points in the judgment of the need to be on guard about that.
Sorry, you referred there to sampling, and of course I acknowledge once again that I may have missed something here. But did the judge find that Apple, in its negotiations with each of the counterparties, had said to them, let's proceed by sampling?
It's quite close, and I'm coming to that in a few moments, but yeah, the answer is it's quite close. What he does do...
Well, why does he repeatedly condemn the patent by patent approach? Because, of course, the patent by patent is not sampling.
No, it is not. It is again, if I may say so, without undue criticism of the judge, it's perhaps not the phraseology he should have used in every case, because in this judgment, in quite a number of the instances where the judge refers to patent by patent negotiation, he appears to be including sampling within that expression, I'm afraid. So I need to clear that straight away. But to answer your lordship's point, and I'll show you in a few moments, we'll look at that, but he takes as a representative way in which Apple approaches things one particular case, which is the way it dealt with this licensor with a portfolio of around 7,000 patents, it says in the judgment, Innovius, connected with Optis. And he shows that as their representative behaviour, what is tabled is a sample of 28 patents, and the argument proceeds on that basis. Similarly, he had, of course, the Optis-Apple negotiation debated in front of him, where, again, a similar approach he saw was taken. But the judgment refers to that other deal as being representative, and I will take you to it in a moment. If I may begin by going to page 452. This is the reference to the Oscar Wilde. It's the previous page. So, in relation to the commercial negotiations, a key paragraph on page 451, I apologise, is 417 Roman 3 at C. I accept as a basic truism that where there's a mismatch in corporate size, there's the opportunity for the exercise of improper market pressure. I can only say that I have seen no evidence of this, but I will be astute when considering what I gain from the various comparables to bear this point in mind.
Again, can you help me? And you may say this is just semantics, but the judge refers here to improper market pressure, and in other parts of the judgment he refers to market pressure.
Yes.
Thereby signalling that he sees a difference between proper and improper market pressure. I can only assume that he's referring there to the dividing line between that which is an abuse of a dominant position and that which is not.
Now so I'm not going to speculate. I do not believe that's the only natural interpretation of this phrase, where he refers to the use of.
Can you? And improper market pressure is also used in little b. It's not just in little c.
And that is because
it's not an isolated use of the expression. So in your submission, what did the judge mean by it?
Well, what I had in mind, my lord, is something that Lord Justice Birss referred to earlier in this hearing, which is that it is possible to behave in a way which is undesirable or illegitimate, which is unfriendly, but which is not an abuse, as your lordship says, of a dominant position. So that would be the exercise of market power, which was not unlawful in competition law terms. It would be undesirable from the point of view of, through the lens of a Fran court looking at matters now. So those are two categories. There is a third category, which is the use of legitimate market power. And that is a situation where you have two parties negotiating on different sides of the table. One of them is a more powerful entity. One of them is able, almost inherently, to strike a better deal, and not for reasons necessarily concerned with hold out, if it's that way round. But the judge appears to think at a certain point in his judgment that there is that category of pressure that can be applied, which would be...
But he can't mean, when he says improper market pressure, that includes what you have just described as legitimate market power.
No, he can't mean that. It must mean one of the two other variants. It must mean either behaviour, as you say, abusive, or at least involving a practice which, from a Fran point of view, is illegitimate.
Mr. Taylor, can I do apologise for asking this question, but it's bugging me, and so I'm afraid I'm going to ask you. It's dawned on me what's been bugging me about this paragraph and other similar things elsewhere.
Yes.
If you look at the judge's own table 13, which is on page 489, a thing the judge did, which I don't think was at least as clear or as explicit in the other evidence that was before him, part of the consequence of the way he did his method,
Yes.
was he put all the comparables he was using on a common scale, which was the stack
Yes.
value. And that's what happens in table 13.
Yes.
And we can to make it easy. I'm not bothered about Qualcomm particularly. I mean, I don't actually think you need to take it out, but it doesn't make any difference. But what that allows you to do is look at all of those licenses and look at what they imply about the total stack. So you're measuring the licenses against each other in this table. You can see them against each other on a common scale.
Yes, you can. Yes.
And they vary by a factor of 10, in fact more than that. So on that common scale, they can't all be franned.
That is right. And so the way that
But the judge said they're all franned.
he certainly does not say that in relation to one. So
Oh, well, you're right. Well, take out Qualcomm, I get that.
and BlackBerry at the top.
Okay, take out BlackBerry. Still doesn't it? You've still got, InterDigital is at 4. There's a number for InterDigital. And there's a number for others, and the numbers are there's an order of magnitude difference between the numbers on there. Now, either that's the Fran range, and they're all Fran because that's the range, in which case it's up to your opponents to pick the top on the authorities, or they're not. Some of them are not franned, and surely that's a perfectly natural inference. That's why I have such difficulty with the idea that I see no evidence, he says, of and it's not a question of competition law, none of that. It's just what's... So once you put them on a common scale, you can compare them in that way.
Of course. So, my lord, the answer to that, as I apprehend, is that these are implied average values from each license, all scaled up. He doesn't know, however, what's going into each license negotiation. His approach, which I haven't taken you to the language of or orally, but he says at 2 points in his judgment, is to be as inclusive as possible. And his understanding is that although there will be some imperfections in the sense that perhaps some of these are going to involve matters that are unrepresentative, possibly because they include other matters which change the number, possibly, and he deals with it later, because some of them involve smaller counterparties where he enters a form of correction later. His approach is that the right approach for him to adopt is to be inclusive, look at all of this data and take an average of it, rather than saying to himself, each of these is by definition FRAND, therefore the top one marks the top of a range and the bottom one marks the bottom of a FRAND range. He's seeking to approach the FRAND question in a slightly different way by saying, I don't know precisely what's in all of this imperfect data, so I'm going to use an average.
Yes.
That's how he
Well, that's what he does.
yes, and that's how he sees it. Now, back on page 451, we have in Roman 3, about 5 lines down, this point that my Lord Justice Birss referred to before the short adjournment. He says, I've not seen any evidence of the rates that Apple achieved being unduly low through the exercise of holdout. And then he says, I appreciate that this is a sort of loop because I don't know. I don't know what I'm looking for. However, what he means is, and he's used the phrase unduly low elsewhere in the paragraph I already took you to, is I don't see that this particular practice from any of the instances that I saw being debated in the cross-examination and read about, led to rates that I can expect to have been made lower than they otherwise would because of holdout practices, is our best understanding of what that must mean. And then below that at 418, he says he recognises in the third line, I must tread warily in relation to all of the comparables, which connects with the point that he says, well, none of these can be taken as in itself individually a reliable comparable to lead to a FRAND figure, in my view. He is saying that the better course is to say it all comes out in the wash by averaging it. And then finally, and we saw this before, at pages 480 and 481, you had at the bottom of the page, 481 Roman 4, where he has said that where he sees, where he is concerned that Apple may have been able to get higher rates from the smaller counterparties, he's going to try to factor that into his assessment. And in answer to my Lord Justice Arnold, he's clearly not referring there to at least to abuse of dominance on Apple's part. It appears to us that he is talking about simply being a more powerful party in negotiations, and therefore not referring to illegitimate conduct either in the sense of holdout tactics. But he's saying in a more general sense, what I'm trying to do with all of these comparables, which involve unknown things going into the amount of money that I'm considering, which concern unknown circumstances of negotiation in many cases, are matters that I'm going to deal with through the power of averaging. And his conclusion on page 451, back at 4...
You've just referred to unknown circumstances. Can you just help me on this? One appreciates that in these cases there's a huge amount of evidence. One also appreciates that for perfectly sensible reasons, parties sometimes agree limits on the evidence, and even if they don't agree, judges impose it for case management reasons. Was there not disclosure in relation to the negotiations of each of the comparable licenses relied on?
Yes.
Right. So there wasn't a complete informational vacuum.
No, absolutely. What he didn't have, if I recollect precisely, was he didn't have all of the internal thinking of the party. What he did have is the external negotiations, and it was by no means an informational vacuum, absolutely. But he was aware, as he says at various points in the judgment, for example, in relation...
Yeah, so take a random counterparty. Obviously, he didn't have
Yes.
disclosure of Ericsson's internal thinking,
Yes.
because they're not a party. But he would have had the manifestation of their thinking insofar as you can divine it from the negotiations.
Yes, yes, exactly. He did have that, absolutely. Now, his conclusion on page 451 at paragraph 417, and it's Roman 3, is, as I say, that Apple did not, he's seen no evidence of Apple achieving unduly low rates through the exercise of holdout. And my lord, that includes, therefore, taking into account the sort of information that your lordship rightly reminds me was before him. Our case is that on appeal, this should be the start and end of the point. My learned friend said on Wednesday that he's relying on the findings made by the judge. But the findings made by the judge include also the findings that the rates, that he'd seen nothing to suggest the rates had been depressed by the holdout. So Optis is not accepting those findings in 4173. They refer to the proposition that the findings back in paragraphs 206 and 207 in particular, which Mr. Speck took you to, those must mean that there has been holdout in the sense of conduct that can be expected to have produced a depressive effect sufficient to vitiate the comparables, although the judge, with some clarity, because he said he was on guard as to this, looked at that issue directly, and his finding was the opposite. There were essentially 4 parts to Optis's argument about systematic holdout by Apple. The first of these is that there was holdout by Apple in all its licensing negotiations in the form of threats of patent by patent litigation, by which I mean, in the true sense of will every single patent you're asserting against us, we're going to need to see is valid and infringed.
It's not just that. Look at 206, where he's setting out, if you tell me that he's got your case completely wrong, please tell me. In other words, no licensee could be compelled to take a portfolio license if it did not wish to do so. So that's patent by patent licensing. And he says you defended that throughout the trial. Is he wrong?
He is not wrong to say that in these negotiations,
this is your stance at trial. This is not about negotiations. He says Apple defended throughout the trial.
He is not wrong to say that at trial, we did not demur from the point that what you saw on the Apple website was indeed a part of the negotiations that took place with the counterparties. What we do contest is a finding that beyond that point, there was either patent by patent negotiation in the full sense, or indeed patent by patent negotiation in a sense that would have been a strong reason to expect that there was sub-frand rates produced by the behaviour. And I'll be coming on to that in just one moment. The judge did say that there was this behaviour. I am going to look in a moment at what that actually meant in context, because what is said against us is that this is some important feature of the negotiation which can lead to the presumption that there were subframed rates. And we say that is not the correct analysis, and nor is it the analysis that the judge himself, being aware of this point, came to. So, if I start then with the suggestion that Apple negotiated on the basis of threats of patent by patent litigation for the whole portfolio, and we go to the two paragraphs that my Lord Justice Arnold refers to, 206 and 207, we do have to focus on what is said there. In a nutshell, our submission is that this is a case where Apple is saying that ultimately our legal right is to challenge patent by patent. Third line of 206, in other words, no licensee could be compelled to take a portfolio license if it did not wish to. And the judge goes on in the very next sentence, at the beginning of 207, to make an important point. He says, in a nutshell, he says, the fact is that this insistence on at least the potential for a patent by patent review was generally present in Apple's approach to negotiations. In other words, they post that this is ultimately what we can do, but that is the finding of fact. What the judge does do is go on to say that the negotiations about portfolios are frequently, and indeed the judge might well have said routinely, conducted on the basis of testing a sample. And this is where the point I made earlier comes in, that the judge selects as a typical example of Apple's approach on the facing page, paragraphs 208 to 210, the negotiations with this entity Innovius, which is, you'll see it referred to there in the footnote at the bottom of the page. And he comments at the top of page 345, paragraph 210, that what one sees is active and prompt engagement by Apple's technical team with a group of claim charts, which was a sample. You'll see in 208 it was a sample of 28 out of the 7,000 that were presented. And the figure of almost 7,000 for your note you get from...
Sorry, the 28 claim charts were sent by Innovius, yes?
Yes, they are. They're sent, exactly, they're sent by Innovius as part of portfolio negotiations. And what I'm going to show you in a moment is the way that these come in, which is that Apple's position is to say, you tell us which are the patents you wish us to assess as your...
Well, sorry, am I wrong in misunderstanding that the essential response to the 28 claim charts is none of them are valid and infringed?
No, you're not wrong about that. That is what they said.
Right.
And I'm going to explore the negotiating dynamic in a moment. But that in itself...
So the stance was, we don't need a license.
The stance was, we are not... So, let me show you what underlies the bonnet. But the stance is, we're negotiating about a portfolio. You put forward a sample of patents for us to consider, and they choose it. Then, as Mr. Speck rightly observed, two, the response is, in pretty well all these cases, if not all of them, we don't accept that these are valid and infringed. That is in the open correspondence. The parties continue negotiating a portfolio license on a global basis. The evidence that was given by the witnesses who were explaining this to the judge was that what is happening is that in open correspondence, neither side says, I'm going to admit this on either side of the case. Either this is valid or this is not valid. but both parties are testing each other's positions, and they do a deal based on an appreciation without it being recorded that there's any admissions or concessions in open correspondence, based on the respective view about the real merits of the portfolio and what would happen if there were disputes that were tested.
Yes, but what that is not, and you will correct me if the evidence was different, what that is not is a negotiation based on the implementer saying, yes, of course I need a license, now let's talk about Turkey about how much.
That's right. It's not done on that basis.
No.
Or at least, it is. You're quite right, it's not done openly on that basis. The witness evidence that was given and cross-examined on, and I'll show you a little bit of that so you see it, is that they go back to their respective teams, they take a view.
If your position is that this is all perfectly legitimate and not in the least symptomatic of holdout, why on earth would the implementer not accept that they need a license? Because the reality is everybody knows they need a license. The question is how much. So the transparent thing to do would be to negotiate on the basis that I've suggested. But instead, what we get is every time a claim chart is sent, the response is no, not valid, not infringed.
Yes.
We don't need a license. That's always the response.
Well, my lord, that is what happens, but we say that is not the nub of the question. That is the position taken with a view to the fact that if negotiations do not ultimately end up in an agreed deal and there's litigation, neither side wants it to be on the record that there is that sort of problem. And the commercial point that was explained by the Apple witnesses is that the way things do tend to be done by way of convention is that admissions are not made, but the parties do understand each other's positions. They approach things in terms of risk.
Last question on this. What on earth is the problem with the implementer saying we do not admit that any particular patent is valid or essential or infringed, but nevertheless we accept that we do need a license, and let's now negotiate on that basis?
Well, my lord, on that matter, I am not going to say, because I do not know, whether in any of these cases, or perhaps many of them, that is actually said. Because the point that was put by Mr.
It's never happened in any of these.
Well, one needs to be careful and one needs to be scrupulously accurate, because the point that the judge made in response to Optis's submissions was not saying we never need a license. It was just not admitting in open correspondence validity and essentiality. That is what happens. And whether one is saying we're not going to make any formal admissions of this, but let's discuss matters sensibly based on the risks. My submission is that it's entirely plausible that those sorts of discussions do happen. I'm not going to give evidence about that on my feet. I'm merely going to say that the point that was put at the trial, and which is renewed here, is that you can draw the conclusion of holdout from the fact that I've now debated with your lordship, that one party says, Apple says to the others, we are not going to admit formally that any of these patents are valid and infringed. And the judge makes the point, that one wouldn't expect that to happen in the course of commercial negotiations. I'll be giving the reference in a few moments. 207 Roman 3. Thank you. 207, yeah, there you are. 207 Roman 3 is the judge's take on that. Foot of page 343. We can understand why in open correspondence, an implementer like Apple would be no more likely to admit the validity or essentiality of a single patent than the SEP owner would be to accept its invalidity or essentiality. Such concessions are simply not pointful. So now, which is something that I'm not going to pick up on. That was addressed with Mr. Speck. But he says, for reasons that are obvious and understandable, it's not a course that would commend itself to a SEP owner. It certainly did not commend itself to Optis to make any admissions either. And he's saying that on both sides this doesn't happen. What the evidence received by the judge was that this happens openly, but the parties themselves are testing each other's positions and then talk in terms of risk with each other, in the course of which a substantial offer is made, which then may not be agreed, and then there's litigation. Then the point taken by Optis is that where the substantial offer is made, that's an offer that's essentially you're capitulating, you've been softened up, and it's a low sub-frand offer. Our response is, no, that is not a necessary corollary at all. Where a substantial offer is made, it is consistent with an appreciation on both sides of the risk. And when Apple negotiates with the likes of Ericsson or Nokia or InterDigital, to paraphrase something you're about to see in a moment, it does not get cut price rates. Now, I was referring to that example from Innovius, and I have mentioned now in the exchange with my Lord the evidence that supports these points, which says that you cannot interpret the fact that one party does not make these admissions openly as evidence of behaviour that produces the unreliable comparables because of the way things were explained. If you would please pick up a couple of references so I can illuminate that better. If you go into Sup 1 at tab 21, that is an extraordinarily long tab comprising many extracts from transcripts. And may I ask you please to turn to page 357. This was the cross-examination by my friend of one of the Apple negotiators, a gentleman called Mr. Ankenbrand. And if you look at the top left tile, just begin at line 6, Judge says, Mr. Ankenbrand, you said about 5 minutes ago that in a SEP negotiation, you've always gone through a technical analysis of the patents. Does that mean when you've a particularly large portfolio, you do a sample? Or do you literally mean you go through every one? Answer, it means the former, my lord. Typically, we don't try to dictate how many charts the other side gives us. So if a party chooses to give us 10 charts, we'll look at 10. If they choose to give us 25, we'll look at 25. In some cases, they'll choose to give us so many we can't realistically look at all of them. So there may be cases in which they give us hundreds and we look at tens. So that's the sort of a flavour of the discussion, because the judge asks the witnesses, how are these things done? What happens in negotiations? No, I'm told that while I'm on that page, I may as well also refer to the bottom right-hand tile at at page 1239, and if you pick it up with Mr. Speck's question to the witness at line 17, Mr. Ankenbrand, what I have to suggest to you is that Apple is always finding some reason to say that you believe the patents put forward on the other side is either not essential or invalid. It's a very good stance to take in negotiations, because you're putting the patent owner in a position of having to face the prospect of seeking to sue Apple patent by patent, or drop its ask. You're well aware of that, aren't you? Answer, I would not draw a direct line between those two. I think sophisticated negotiators understand that a negotiation, and by the way, most people we negotiate with are sophisticated, they understand that a negotiation is about hybrid adversarial and collaborative process. Yes, hybrid. We're collaborating to try and reach an agreement, but at the same time, we recognise the possibility that litigation may ensue, So unfortunately, sometimes you will see they are accurate, right? These communications are absolutely accurate. You can see by the backup that we had a basis to allege that every single one of the patents wasn't essential or invalid. But it's in the face-to-face communications that the really helpful information is often exchanged.
Yeah, look at the next question and answer.
Well,
do you not see the difference between looking for a basis to say you might win on an individual patent is very different from saying you're going to win on all of them? Answer, this does not say we're going to win on all of them. This is saying you have not proven to us that any of them are both valid and essential. And so we're not going to take a license until you prove that there's valid and essential patents.
Sorry, if we just carry on then and just read the remainder of the... he says, by the way, when you combine that, sorry to interrupt, go ahead, it's me who's not allowed to interrupt you. I was just going to say, if you look at these communications in context with the fact, for instance, that we are actually giving them an offer, nobody would take those two things together to suggest that we don't think there is a risk that there is some essentiality in their portfolio. So I see your lordship's point, but what you have here is the commercial witness explaining that the convention seems to be, in his experience, that they approach things in this way. They make an offer while making these formal positions clear. And that does not mean that either side is under any illusion in reality that Apple is going to say, I'm suing you patent by patent. This is their discourse.
And the exchange goes on 1241. It's exactly what Mr. Speck was putting to the witness.
Well, and the answer is the same, my lord. I don't myself see anything further in there that adds to the point on this. However, what we have seen shows what the witness is explaining to the court. So, my lord, that is what we say about how the judge appreciated that commercial negotiations in this field take place, and therefore why it is that the omission by Apple in these formal negotiations to make open statements that it admits that there are valid or essential patents is not going to undermine the reliability of the comparables for the reasons he explained, which I won't go back over again. If we go back to 206 and 207, we have the points of context referred to by the judge in 207.
So, Turner, in 207 at the beginning, the first sentence, you emphasised the word potential. You remember that? Insistence on at least the potential for patent by patent review. If you turned that around and referred to the SEP owner and identified the SEP owner as insisting on the potential for an injunction, you would call that holder.
Well, my lord, if that were, I'm not for one moment saying that that perhaps doesn't happen.
No,
and the description.
That's not my point.
If your lordship likes, because let me follow that train of thought. Let's assume that we do go into the negotiations. And on Apple's side, it says you do realise that ultimately, as a matter of law, as things stood at that time, we can get you to prove the validity and essentiality of the patents for which you want payment. And on the other side, the licensor says, well, you do realise that we have this power too. I'm not excluding that for a moment, but as I said in my opening address, you then have two opposing vectors, and you have a clash. You have sophisticated parties perhaps making these sorts of threats to each other. That goes on with your arsenal behind you when you negotiate. And what the witness explains is that then in the front line, the negotiators sit down and they test each other's patents. That's the technical testing of the sample. At the same time, substantial offers are made. the witness's evidence is that the nature of those substantial offers is that they're calibrated to reflect the risks perceived on either side. And then, generally speaking, offers are agreed to and there is a deal. That's the process that is explained. My Lord, in 207, we have the 3 points of context. The first of those illuminates the point that my Lord Justice Arnold referred to, because the proposition is that the judge finds that there's this patent by patent behaviour, but the first point is not consistent with that, because the judge is saying, well, when you're faced with an offer, the only thing you can do is to sample. So he must mean there, when he's talking about patent by patent, at least on a sampling basis. The second point, 2, is that Apple frequently does take licenses without individual examination. And I've said that that is, he could have said, routinely. And the third point is that it isn't pointful to observe that in open correspondence you don't make these submissions, which we've now covered. So, I think I have now covered all I wanted to say about that. The next point to make is a response to how Mr. Speck addressed this. He took you to his Annex 3 of his skeleton, which form part of a larger part of Optis's closing submissions, which are the extracts from their case, picking out parts of the evidence that were favourable to them in order to persuade the judge to find that, that the evidence he had seen should lead him to expect sub-frand rates. Now, in particular, he emphasised a letter from Apple to Ericsson back in October 2014, and he said this was revealing of a cynical strategy to his words. He said to the court, this is not Apple's submission, devalue SEPs. Insofar as this means pay less for SEPs than they are really worth, a mere glance at that letter shows you that Optis is wrong to say it, and the relevant part is actually quoted conveniently in the judgment itself, and that was because counsel cross-examined Miss Muse extensively on it. That's at page 369. And you'll see at footnote 356 the quote from this letter, referencing it's page 203 of the trial bundle, and the long extract is set out. And you'll see the perspective of Apple, which is reflected in the first paragraph. And in material part, it's interesting because Apple is explaining for that case, that the threat of injunctive relief on SEPs from Ericsson back in 2007, when the iPhone was launching that year, led Apple to pay over the odds. And that was the context, it's explained, for Apple's proposition in the renegotiation that a frand rate would be lower. It was not a cynical attempt to pay an unfairly low amount. And the judge accepts this point, and we say reasonably, pages 371 to 372, just over the page, led to his statement that what's demonstrated here are hard-fought negotiations and not unfair negotiations between two large corporations who can quite easily look after themselves. And the outcomes that they were seeking, you see in the blue confidential highlighting. Now, I've already taken your lordships to a small number of examples of the primary evidence before the judge, and I'm not going to go through seriatim everything, let alone what's here in the bundles, because in my submission to do that would be to treat this court as a second court of first instance, whereas the target, my friend, is to say that this judge behaved unreasonably in the findings that he made. My point is simply that all of this, not simply the edited highlights that Optis presented in its trial closings below, and which Mr. Speck went through on Wednesday, all of this was before the judge, and the judge reached conclusions, including about the evidence that I've now shown you, the contextual factors that he's referred to, in the light of all of that. Now, Mel, can you just remind me, is it 3 o'clock?
It is 3 o'clock, and I'm afraid there's a strict deadline of 3 o'clock.
Right.
Does that mean it's not really worth embarking on the next bit?
I probably ought not to, in case I say something that usually is of interest to your lordship, which then leads to a discussion. So I think perhaps, with your lordship's leave, we'll up sticks here.
Can I raise a point?
Yes.
I was quite concerned at one of the submissions my friend made several times, which seemed to suggest that the correspondence that we had between parties was open correspondence, but the real deal was being done elsewhere. I just want to be clear whether or not my friend is making that submission, that there is a separate line of correspondence that we didn't get.
No, I'm not saying that at all. I'm saying that all of the correspondence was subject to disclosure. That's not the point. The point is that if there are discussions,
Okay, face to face.
yeah, exactly.
So oral discussions may be deliberately so as not to leave any interest.
This is not. I understand, but there was no failure in disclosure obligations. No.
In which case we'll leave it there, but start again at 10 o'clock on Monday.